Ms. Thompson.
Thank you. Mrs. Carnan, over the lunch recess, several of my colleagues brought to my attention the part in the analysis that we were both looking for earlier on without success.
Right.
So just for completeness, we don't need it on the screen, but you have a hard copy there, I think. It's on page 13.
Yes.
And it's the second paragraph down. On one view, the now deceased was walking along the road in a normal manner without a knife and seeming not to present a danger to the public,
Yes.
and so on. Grand. That was just to tie off that loose end. Just before lunch, we turned away from use of force and we turned our attention to the question of causation. And I took you to your first statement where you said that the question of whether use of force by the police officers had caused the death of Shekobaya was explored in great depth, and the report to Crown Counsel fully addressed the available evidence. And then we looked at the analysis, page 24, where you said that the extent to which the role of restraint contributed to the death is not known and cannot be excluded completely. And that is where we were at lunchtime. Would it help to have that second comment up on the screen again, or do you have it in front of you?
I've got it now,
You've
page
got
24.
it there.
Yep.
It was on page 24 in the first paragraph. Now, so far as I can see, although you make the statement in the analysis that the extent to which the role of restraint contributed to the death is not known but cannot be excluded completely, so far as I can see, nowhere in the analysis do you set out the legal test for establishing causation.
I think the medical evidence was considered in the narrative and it wasn't addressed in the analysis to any extent. It was set out simply in the narrative.
Well, we're going to look at the narrative shortly, and we're going to look at the summaries contained within the narrative of the conclusions reached by the various experts who were instructed.
Yes.
But I'll be corrected if I'm wrong, I don't think anywhere in the analysis is the legal test for causation set out, or do we see that anywhere in the narrative?
Okay.
If you see that test set out as we work our way through the narrative or the analysis, please do tell me. But to the best of your recollection, you were carrying out the legal analysis of the evidence. Did you set out the test for establishing causation?
I think my approach to analysis was to, I think, as set out in that first paragraph, was to assume that there was or there may have been some causal link. But I think when you look at the expert opinion, I think some of the experts have said actually police restraint or that the involvement in the police may not have had an impact at all.
So your understanding was that there was or may have been a causal link.
Yes.
You say that when we look at what the experts said, some of them thought there may not have been an impact.
That's right.
At all. Is
That's
that
right.
perhaps not all the more reason to set out in the analysis the legal test for causation and then apply that test to the opinions of the experts?
Again, in hindsight, possibly.
Where could you have looked for guidance on causation?
Presumably the knowledge bank.
Okay, did you do that?
No.
Did you have a discussion with Mr. Brown about causation?
I don't recall that, although we had a discussion about what the medical experts said because he was providing updates when consultations had taken place.
And what did you understand was required for there to be a causal link between any potentially unlawful actions on the part of the police and the cause of death?
That there was some link.
That there was some link. Now, there's no mention of the post-mortem report itself in the analysis, but it is discussed
Yes.
in the narrative, and I wonder
Yes.
if it might be helpful to remind ourselves what conclusions the pathologists who carried out the autopsy reached. So I wonder if we can bring up the narrative, please. And can we go to page 78, please? Now, again, I appreciate that you didn't draft the narrative, Mrs.
No.
Carnan, but it's a convenient way for us to review the opinions of the experts, because
Yes.
they've all helpfully been summarised by your colleagues. So we'll use the narrative for that purpose. So this is the section that repeats verbatim what was said in the concluding paragraphs of the post-mortem report. Taking everything into consideration, the pathologists noted his death was sudden in nature. In summary, there was no evidence of gross or histological natural disease that would account for death. Toxicology revealed MDMA and alpha-PVP, and these drugs could potentially have caused sudden death at any time due to a fatal cardiac arrhythmia. That said, it is recognised that restraint in itself can be a cause or contributing factor in some deaths, and given the circumstances, in that this man was restrained at the time of his respiratory arrest, and post-mortem examination showed petechial hemorrhages which may represent a degree of asphyxia, it could not be completely excluded that restraint also played a role in the deceased's death. And if we scroll down a little, please. Overall, it was not possible to be sure what was the most significant factor in the death, and as such, the cause of death was best regarded as 1A, sudden death in a man intoxicated by MDMA, ecstasy, and alpha-PVP whilst being restrained. So we see here that the pathologists who prepared this report, if we can scroll to the paragraph above again, please, recognised that restraint in itself can be a cause or contributing factor in some deaths. Mr. Bio was restrained at the time of his respiratory arrest. Petechial hemorrhages may represent a degree of asphyxia, and therefore restraint cannot be completely excluded as having had a role to play in death.
Yes.
So that's what they had to say. And they certified the cause of death as being sudden death in a man intoxicated by MDMA and alpha-PVP whilst being restrained. Mrs. Carnan, are you familiar with the phrase de minimis?
Yes.
Do you understand it to refer to something that's trifling or insignificant?
Yes.
And are you familiar with the phrase material contribution?
Yes.
And do you understand a material contribution to be one that is more than de minimis?
Yes.
So where the post-mortem report says that restraint can be a cause or contributing factor in a death, and it cannot be completely excluded that restraint had a role to play in death here, did you understand that the pathologists were saying that the role of restraint was de minimis, or did you understand that they were saying that restraint made a material contribution to death?
I understood that they weren't in a position to say one way or the other.
Was that question asked of them at recognition?
I didn't recognise them.
Now, we've heard evidence that the cause of death was multifactorial. Was
Yes.
that your understanding?
Yes.
And the cause of death, which would have been repeated on the death certificate, lists ecstasy, alpha-PVP, and restraint. So restraint is mentioned not only in the narrative of the death report, but in the actual cause of death and on the death certificate itself,
Yes.
as part of a narrative cause of death. And it's listed under Part 1A, which Dr. Shearer explained in her evidence, is the primary cause of death. With your experience of working in deaths units, would you understand that 1A is a primary cause of death?
Yes.
And under 1A here, the pathologists who performed the autopsy considered that restraint was worthy of mention.
Yes, although the wording is whilst being restrained rather than caused by restraint.
Well, did that not create, at the very least, a question mark in your mind as to whether there was a need to go back to Dr. Shearer and clarify that particular point?
I understood that Crown Counsel had consulted with Dr. Shearer following further expert reports. I'd need to see what Dr. Shearer said in consultation, but my understanding was that she agreed that death could have taken place without police involvement.
And was this consultation note made available to you?
I think it was, yes.
Okay. I don't have that to hand, but we can perhaps revisit that after the afternoon break. Let's go back to the narrative and look at the summaries of the other reports, because I understand that a variety of experts were instructed in this case. We don't need to look at all of the summaries, really only those that offered a view on cause of death. So, for example, Dr. Lipsage, who was an eminent consultant psychiatrist, we don't need to look at the summary of his report because he wasn't a pathologist. But let's look at those that do bear on cause of death. So we've looked at the post-mortem report as a starting place. If we could perhaps now move to page 84. Now, here we are looking at a report prepared by a Dr. John Parks. We can stay on page 84, but page 83 explains that he's a senior lecturer at the Faculty of Health and Life Sciences at Coventry University. Was he medically qualified?
I'd need to have a look at the report.
Okay. In any event, because his report is summarised in the narrative, let's look at it. If we can look at the bottom part of page 84, please. The final paragraph on that page. And we can read it short. In conclusion, the precise contribution of restraint to the death could not be determined with certainty. And at the very bottom of that page, and again, this is a lift from his report, I think. On balance of probabilities, the most likely impact of restraint is that the restraint contributed to the death of a man who is also at risk of sudden death due to the consumption of illicit drugs. So that was his opinion, leaving to one side the question of his experience and expertise and qualification. His opinion is that on balance of probabilities, the restraint contributed to the death of a man who was also at risk of sudden death due to the consumption of illicit drugs. If you have an expert telling you that the role of restraint contributed to death, is that more than de minimis?
He doesn't go into the extent to which the role of restraint contributed to the death, so I'm not able to comment beyond what the words say.
Well, if he says it contributed, we know that anything that is trifling or insignificant and might be considered to be de minimis can effectively be left out of account. So here we have, do we not, an expert saying that restraint contributed to the death. It would be reasonable to infer, might it not, that his opinion was that the role played by restraint was more than de minimis.
I don't know. I'm not able to comment other than what he said. I think it would need to be explored with him.
All right. And was it explored with him?
I don't know.
If there was a question mark over whether he was saying that the role played by restraint was more than de minimis, is that not a matter that should have been clarified with him?
I didn't do that.
You didn't do that. When you were preparing your analysis, you would have looked at the report prepared by Dr. Shearer, or at least the summary of her report.
I looked at all of the
You
medical.
looked at all of the reports.
I looked at all of the reports.
So far, we've only looked at two, Dr.
Yes.
Shearer's report and Dr. Park's report. And in relation to both reports, you express yourself uncertain as to what the experts were saying with regard to the role played by restraint. Now, if you are preparing your analysis effectively as a desktop exercise, and these matters hadn't been clarified to your satisfaction, was that not something that you might have brought to the attention of Mr. Brown?
I think there were a number of experts instructed, and I looked at all of them and carried out my exercise based on all of the evidence.
Okay. Well, considering them one at a time, if you were in doubt as to the role that Dr. Shearer considered was played by restraint, or if you were in doubt as to what Dr. Parks meant when he said the restraint contributed to the death of a man who was also at risk of sudden death due to the consumption of illicit drugs, would it have been open to you to say to Mr. Brown, there's an ambiguity here, or I'm not quite sure what these experts mean. These points require to be clarified. Can that be done, please, whether it be through consultation or recognition?
I wasn't involved in the medical side of things, if you like. That was not part of my analysis. I was looking at the police restraint, and my analysis of evidence brought together all the information I had to hand, but I was not involved in a discussion about the medical expert evidence.
You may not have been involved in that discussion, but you were responsible for preparing the analysis.
Yes.
And the analysis applies the law to the facts.
It does.
So that would, one might think, involve looking at the test for causation and looking at how that test sat in relation to the opinions expressed by the various experts.
I accept that.
And I wonder if you accept that if there was a question mark in your mind as to what Dr. Shearer meant or what Dr. Parks meant, it would have been open to you to go back to Mr. Brown and say, this needs to be clarified. I can't answer this critical part of the analysis without clarification.
I don't think I was in difficulty with Dr. Shearer because I'd seen the PM report but also her consultation notes. I can't recall whether Dr. Parks, there was a consultation with Dr. Parks or not.
In either case, if Dr. Shearer had clarified what she considered the role of restraint to have been, and if Dr. Parks had clarified recognition or consultation what he meant when he said the restraint contributed to the death, might we have expected to see that set out here in the narrative?
Sorry, the follow-up of consultation notes, I'm not sure that that would have happened, no.
So if an expert prepares a report,
Yes.
and there's something in the report that is ambiguous or requires clarification, and the fiscal clarifies that matter through consultation or recognition, as the case may be, would we not expect to see that additional level of clarification and detail set out in the body of the recognition?
Yes, if the fiscal had done that, but if Crown Council had done it, no.
But you certainly didn't consult with Dr. Shearer,
No,
and so far as Dr. Parks is concerned, you didn't consult with him either.
no,
Do you recall having seen notes of a recognition or a consultation?
I don't recall.
At the time that you prepared the analysis, and at the time that you read his report, was there a question mark in your mind as to what he meant when he said the restraint contributed to the death?
I don't think there was a question mark. I think what you were saying was that on the balance of probabilities, restraint in some way contributed to the death, but there was also the risk of sudden death due to the consumption of illicit drugs. So the extent to which the restraint played a role couldn't really be determined. That's what I understood him to say.
All right, although he does say clearly in terms that the restraint contributed to this man's death, even though he was already at risk of death.
He says it's unlikely that the restraint made no contribution, but he doesn't elaborate as to the extent the contribution made.
And is that not a matter that it might have assisted you to have had clarified, whether he was saying that the restraint was de minimis or whether it made a material contribution to death?
It may have done, but I understood that the clarification came from other witnesses in relation to that question.
All right. Let's look at the other witnesses then and what they had to say. I wonder if we can move on to page 88. This is a discussion of the report prepared by Dr. Anthony Bleetman, who is a consultant in emergency medicine. And I wonder if we can look at the bottom paragraph on page 88, please. The use of force and eventual restraint will result in a degree of immobilization. Before any restraint, an individual will have already accrued a significant oxygen debt, and any immobilization will carry the risk of restricting chest and diaphragmatic movement. This, even if modest, may compromise an individual's ability to restore adequate oxygenation and address the oxygen debt. A prolonged struggle on the ground will compound an individual's physiological derangements and increase the risk of death. He states that a restraint which compromises breathing efforts may exacerbate an already grave situation. And over the page, please. Second paragraph down. I'm going to read this slightly short, but I will be corrected if I miss anything that is critical. Dr. Bleetman also states that in an individual already in severe oxygen debt due to excited delirium, further compromise of breathing efforts through either prone restraint, possibly, or restriction of chest wall movements by putting weight across the torso, certainly, will put the restrained individual at more risk of asphyxia and will hinder recovery from hypoxia and acidosis. This may reach a critical point at which cardiac arrest occurs. He states that given the poor physiological state of these individuals at the onset of cardiac arrest, recovery is rare in spite of adequate resuscitation attempts. Dr. Bleetman noted the period of restraint was relatively short and concluded that on first contact with the police, the deceased was already at very high risk of cardiovascular collapse due to fatigue and the effects of excited delirium and powerful potentiating drugs, even if there had been no restraint. It is reasonable to assume that the actions of police officers are likely to have had a contributory role in the evolution of the deceased's collapse and subsequent cardiac arrest by adding one more factor to an already lethal brew. In effect, he states the restraint precipitated the cardiovascular collapse that was already likely to have occurred. So what did you understand Dr. Bleetman was saying here, that the restraint or the role of restraint in the death of Shekabayo was de minimis, or that it made a material contribution to death?
I understood that he said that the role of restraint was de minimis because the impact of the impact of excited delirium and the drugs, even if there had been no restraint, was such that he was likely to have collapsed.
He was likely to have collapsed in any event. Was that your understanding?
That was my understanding.
He had to say.
Yes.
Okay. Did anybody consult with Dr. Bleetman, to your knowledge?
I believe so, but I can't remember. I think there are consultation notes.
And did you recognise him?
No.
No. Okay. Let's carry on moving through the reports. Page 93, please. This is Professor Jack Crane, Acting State Pathologist for Northern Ireland. And at the bottom of the page, he says, if respiration was not impeded during restraint cases, it is not the restraint per se which may predispose to cardiac arrest, but its association with the effects of stimulant drugs, along with aggressive and violent behaviour, excitability, and physical and emotional stress. It is a combination of factors which may be considered, albeit the effect of the drugs must be regarded as the principal contributory factor in the fatal course. So here he draws attention to a combination of factors. Yes. He regards drugs as being the principal contributory factor, but that's not to say that the role played by others, other contributing factors, is minimal. Over the page, about halfway down, the role of restraint. A wee bit further down, please. Thank you. The role of restraint is problematic and cannot be determined solely from autopsy findings. if the deceased was being restrained at the time he suffered cardiac arrest, and if that restraint was such as to have impeded respiration, then it would be reasonable to conclude that restraint played a part in the fatal outcome. So what did you understand that Professor Crane was saying with regard to causation?
In relation to restraint,
Yes, did you read his report as saying that restraint was de minimis, trifling, insignificant, or that it made a material contribution to the death?
I understood that he really wasn't able to determine the extent to which restraint played a part.
Okay. So if he couldn't determine the extent to which restraint played a part, or if that wasn't clear to you from your reading of his report, again, is that not a matter that should have been clarified with him?
But my understanding from this and the other experts who offered that opinion was that that was simply the position that you couldn't say from the findings of the post-mortem. You couldn't say.
And which expert offered that opinion that you couldn't say?
I think that's what this witness is saying, that it's frequently not possible to determine from the findings of the post-mortem findings alone if positional or postural asphyxia caused or contributed to the fatal outcome.
Mm-hmm. And he then goes on to say that the role of restraint is problematic and cannot be determined solely from the autopsy findings.
Yeah.
If the deceased was being restrained at the time he suffered cardiac arrest, and if that restraint was such as to have impeded respiration, it would be reasonable to conclude that restraint played a part in the fatal outcome.
Yes.
And at the page we looked at, the page before that, please, 93 at the very bottom, he says it's a combination of factors which may be considered, albeit the drugs must be regarded as the principal contributory factor. So
Yes.
he's recognising that there may have been a causal role played by factors other than drugs.
Yes.
Let's move on to page 95. Dr. Stephen Karch. What did you understand his qualifications and experience to be?
Other than what's written, I would have to go back to his report to make any further comment. I can't recall.
Well, certainly, I think this was one of the reports that was instructed by the PERC.
That's right.
And Kate Frame, who was the commissioner at the relevant time, was asked about this in her evidence. And she said that he was instructed on the basis that he was a cardiac pathologist and a toxicologist. Would that chime with your understanding of the basis on which he was instructed?
I'm really not sure.
You're
I'm not
sure.
able to comment, sorry.
All right. The inquiry has before it a statement prepared by Dr. Karch in which he confirms that he has no formal toxicology qualifications or training as a clinical toxicologist, and further that he's not a forensic pathologist and has in fact never carried out an autopsy. Were you aware of those limitations to his
No.
experience? I think you are aware, because this is covered in one of your statements, that he at one stage spoke with the press
Yes.
about the findings that he reached, having viewed the histology samples. And there was an article in the Sun newspaper.
Yes.
There doesn't seem to be anything about this. Again, I'll be corrected if I'm wrong, but nowhere in the narrative or the analysis is Crown Counsel's attention drawn, or the reader of this report's attention drawn to the fact that that happened.
No.
No, does that surprise you?
I don't know, except I knew that it had been brought to the attention of the Crown. Now, whether Crown Counsel were aware of it before the report was submitted, I don't know.
Is it the sort of thing that you might have expected to see in the narrative? So on the face of it, Dr. Karch is being presented as an expert
Yes.
with
Yes.
who hasn't blotted his copybook.
Yes. I'm not I don't think the opinion of Dr. Karch was particularly relied upon in coming to a view by Crown Counsel.
Okay. But was it particularly relied upon by you in coming to the views that you reached in your analysis?
No, he seemed to be an outlier in relation to all of the opinions they expressed.
And do you make that clear that you haven't relied on his opinion?
I haven't done that. No, clearly I haven't.
Now, Mr. Brown was asked about Dr. Karch and the incident with with him speaking to a journalist and the article in the Sun newspaper. And he says in his statement that the Lord Advocate got to hear about it and expressed the view that Dr. Karch had compromised his duties as an expert, and as a result, the opinion of Dr. Karch would not be relied upon by the Crown.
I think I saw something in correspondence about that.
So I'm just curious to know why Dr. Karch, against that background, features in the narrative at all. And I appreciate that you didn't draft the narrative.
I can't
you
comment
help
for
us
that
with
reason.
that.
No.
And I'm wondering whether it might have been helpful for there to have been an explanation of that background in the narrative, so that anyone reading the narrative who'd perhaps forgotten about the incident with the Sun newspaper might have reminded themselves that there was an issue with this particular expert.
I can't comment.
In any event, let's look at what he had to say at the bottom of page 95. The effect of physical restraint would have been de minimis. So there we have his opinion in terms that the effect of restraint would have been de minimis. He then goes on to say that positional asphyxia is nothing more than junk science. And he also provides some detail as to his findings on review of the histology samples, and as is noted on page 96, that Dr. Karch was the only pathologist who examined the microscope sections of the heart who considered them to show significant morphological abnormalities. All of the others, Dr. Shearer, Dr. Buhaider, Professor Shepherd, Dr. Soliu, Professor Crane and Dr. Carey, either attribute minor changes seen to cardiac arrest and resuscitation or interpret the appearances as being within normal limits. Dr. Karch was the only one to argue the deceased must have had significant pre-existing heart disease, which could have predisposed him to sudden and relatively unexpected cardiac arrest. Is that what you meant when you said he was something of an outlier?
Yes.
Okay. So as well as being an outlier, he has offered a view on causation and said that the effect of physical restraint would have been de minimis. So that was his opinion, but you've told us already you effectively left his opinion out of account.
Yes.
Can we move on to page 96, please, where there's a summary of the report prepared by Dr. Carey, consultant forensic pathologist, who was instructed by Mr. Bayo's family. And at the very bottom we see, in his opinion, the present case had all the ingredients of a case where restraint and struggling had the potential to have caused or contributed to the deceased's death. He noted there was a prolonged period of restraint. The deceased was significantly outnumbered, and on most accounts, restraint was in the prone position. And then further down that page, if we can skip a paragraph, perfect. Dr. Carey states it was not possible to separate the role of any restraint from struggling. As is common in these cases of acute behavioural disturbances, the deceased displayed remarkable strength and stamina. Ongoing restraint and struggling in these circumstances is very likely to lead to significant metabolic disturbances with early breakdown of muscle, releasing potassium, which can precipitate cardiac dysrhythmia and the development of metabolic acidosis. Dr. Carey states that given the presence of potent stimulant drugs, the present case cannot be viewed simply as an example of a case of sudden death during restraint. He entirely supports the pathologist's cause of death, sudden death in a man intoxicated by MDMA and alpha-PVB whilst being restrained, but suggests substituting the phrase whilst being restrained with in association with struggling and restraint. So he has made it clear that given the presence of potent drugs, the present case cannot be viewed simply as an example of a case of sudden death during restraint. He advocates the cause of death put forward by Dr. Shearer being tweaked to include a reference to struggling and restraint, And we saw at the foot of page 96 that he considered that the case had all the ingredients of a case where restraint and struggling had the potential to have caused or contributed to death. So what did you understand Dr. Carey had to say about causation? Did you read these passages as him saying that the role played by restraint was de minimis, or that the role played by restraint in the cause of death was sufficient to make a material contribution?
I understood him to highlight that it wasn't simply the restraint, but the struggling by Mr. Bio against that restraint. So it was a combination of the two rather than simply the restraint that was the issue.
And at the risk of stating the obvious, the struggle wouldn't have happened if he hadn't been restrained. So the two are part and parcel of the same thing.
Yes.
Okay. So you understood that he was drawing attention to the significance of the struggle.
Yes.
That was a response to the restraint.
Yes, the effort required.
Yes, the physical effort to fight against that restraint was important, and he drew attention to it. So did you understand him to be saying then that the restraint and the struggle against that restraint were de minimis, or that they made a material contribution to the cause of death?
I don't think he makes that clear.
You don't think he makes that clear?
I don't think that is clear from the report, and I don't think I applied my mind to that question.
Okay. Well, that's very candid of you. But did you, as the analyst, go back to Mr. Brown or any of your senior colleagues and say, it's not clear to me what he's saying here. This is the test for causation. And when I read the test for causation alongside his report, I'm not clear what he's saying. Can this be clarified?
No, I didn't. Although I was aware that Mr. Brown and Miss Edwards had taken the view of Dr. Lawler as the kind of the Crown pathologist having an overview of all the reports and put all of those questions to him.
All right. Well, we'll come to him shortly, but staying for a moment with Dr. Carey, he's not the first of the experts whose reports that we've looked at where you've perhaps expressed a degree of uncertainty as to exactly what they were saying about causation. Would it have been open to you to have taken your concerns to the door of Mr. Brown and to have said, I'm just not quite sure what this witness is saying, that it needs to be clarified before I, as the analyst, can properly perform my task?
I think I did understand what the experts were saying, and they were all saying what they provided in the report. The question of my analysis, I mean, you've already referred to the fact that my analysis is absent those critical questions. I haven't addressed that.
And I wonder whether, looking back, with the benefit of hindsight, these are questions that might usefully have been addressed in your analysis.
Yes.
Now, you mentioned Dr. Lawler, and I paraphrase, but I think you said that Mr. Brown and Ms. Edwards were taking their lead essentially from Dr. Lawler, who'd been brought in to carry out a review of all of the reports.
He undertook a review with a view to commenting on the approach taken by the experts and whether he had a view about their conclusions.
Okay, well, let's have a look at what Dr. Lawler had to say. At the bottom of page 97,
Yes.
The way that the narrative has been drafted, we've got Dr. Lawler's comment on each of the other experts' reports individually, and then he has a sort of conclusion at the end. So let's have a look at what he had to say about Dr. Carey's report. Paragraph at the bottom of the page. He also strongly supports Dr. Carey's suggested modification of the death certificate, believing the struggling must have been a very important factor in causing the deceased to die when he did. So Dr. Lawler appears to recognise that it's not just the restraint, it's the struggle against the restraint that is important. And he says that the struggling must have been a very important factor in causing the deceased to die when he did. How do you read that from through the lens of causation? what did you understand that Dr. Lawler had to say there? Was he suggesting that the struggle and against the restraint in combination with the struggle were de minimis, or that they were causative in the sense that they made a material contribution to death?
I think going back to the issue of restraint and struggling, you asked me a moment ago about whether the two, in fact, were part of the same. The restraint was down to the police officers. The struggling was down to Mr. Bio. So I suppose it's the extent to which the restraint by the officers had causal implications.
So when analysing whether the restraint was causative of the death, are you suggesting that you should leave out of account the role played by the struggle against the restraint because that was down to Mr. Bio?
Well, it was. You have to. I suppose I was looking at what the role of the police officers was, and the police officers' role was in restraint. The police officers didn't have a role in the struggling.
Okay, and work with me on this hypothesis, if that restraint or any aspect of it were considered to be unlawful because it was more than the minimum, it wasn't necessary, it wasn't proportionate, it wasn't justified, it wasn't reasonable, other use of force options hadn't been precluded. If that restraint or any aspect of it had been unlawful, and Mr. Bio had struggled against that restraint, is that on him?
I think it's a difficult one to separate out, but in the event, those were not my conclusions in terms of the police restraint, and therefore I did not apply that consideration.
I raised that question only because of what you said in your evidence a moment or so ago, that the restraint was on the police, the struggle was on Mr. Bio.
Yes.
It's not unusual for persons who are being detained or restrained to struggle against the police, is it?
No.
And the police, of course, have to keep under review their use of force options at all times.
Yes.
So I suppose if the police had a sense, and again I'm working on a hypothetical example here, but if the police had a sense that someone was struggling to the point of fatigue, then they would have to keep that in mind when they were looking at whether it was appropriate to carry on with the particular use of force options that they had chosen.
I was not aware of anything in the evidence that suggested that was the perception of the police.
Let's go back to Dr. Lawler. We looked at what he had to say about Dr. Carey's conclusions. Can we go to the top of page 99, please? So this, as I understand it, is either a lift or a précis of his report and his conclusions. The struggle in its totality was very important per se and must have contributed substantially to the various metabolic disturbances associated with the psychological and physiological stresses. If it is accepted that the struggle per se contributed significantly to the deceased's death, then it must mean that the act of restraint, whether necessary or not, and whether performed appropriately or not, also contributed significantly to his death, if only because it was a significant, albeit indirect, contributor to the total stress burden affecting the deceased in general and his heart in particular. So you said that Dr. Lawler seemed to be giving something of a steer to Mr. Brown and Ms. Edwards, and tell me if I'm overstating this, but I took what you were saying to mean that essentially if there was a dispute between the experts, Dr. Lawler was being looked to for advice as to how to resolve that.
Yes.
And here he seems to be saying that the struggle was very important and must have contributed substantially to the metabolic disturbances. And if that is accepted, then it must mean that the act of restraint also contributed significantly to death, if only because it was a significant, albeit indirect, contributor to the total stress burden. So what do you understand that Dr. Lawler is saying here about causation? Is he suggesting that the act of restraint was de minimis, or is he giving the opinion that it made a material, perhaps even significant contribution to death?
I think the word significantly is there.
Yep. Okay.
But I think also on page 99 further down, I think it's a further piece of information. He concluded it was never going to be possible to exclude completely the possibility that this aspect of the restraint may have had a minimal contribution to collapse and death, but he thought it very unlikely. And that's when he was talking about the question of asphyxia in the restraint.
Sorry, let's look at that.
Yes. He's talking about the number of petechiae in the eyes and the absence of hemorrhages elsewhere in the face.
Sorry, let's just get this on the screen. I think we've gone too far.
Sorry,
so
it's page 99.
Is it this paragraph? Dr. Lawler was impressed? Was that the paragraph?
I think it was the paragraph above, and then, yes, I quoted from, yeah.
Let's look at that. Sorry, I lost my place there. Given the relatively small number of petechiae on his eyes and the absence of hemorrhages elsewhere in his face, it was not the case that they must reflect some form of asphyxia. Okay?
That's right.
So the petechiae were not necessarily conclusive evidence of asphyxia. Dr. Lawler was impressed by the relatively short period of time between the onset of the restraint and the deceased's collapse. He concluded that it was never going to be possible to exclude completely the possibility that this aspect of the restraint may have had a minimal contribution to collapse and death, but he thought it was very unlikely. Okay, well, the first of those two paragraphs focuses very much on asphyxia, whereas the paragraphs in the various reports that we've considered, perhaps Dr. Bleetman in particular, draw attention to aspects of this part of the restraint that might have been causative of death, leaving asphyxia to one side. So Dr. Bleetman talked about acidosis and oxygen deficit and the restraint and the struggle against the restraint and exhaustion. And that's a separate thing, I think, from asphyxia. The focus, I thought, in your analysis, insofar as this is addressed at all, was very much on asphyxia.
Yes.
Were you looking essentially for evidence that asphyxia was causative of death rather than looking at the restraint in the round?
I think certainly I took the view that asphyxia was would have been a significant matter. Yes.
And we know that the petechiae in and of themselves are not necessarily conclusive evidence of asphyxia. Did you go on to look at the evidence about the restraint more generally, to consider whether, leaving aside the possibility of asphyxia, the restraint might still have been causative of death? For all of the reasons that Dr. Bleetman essentially narrates, this was an individual who was potentially suffering from what was then known as excited delirium, who had taken alpha-PVP, who had taken ecstasy, who was struggling against restraint, who was becoming exhausted.
I think so, but I think my focus was on the question of the knowledge of the officers about what was going on.
Is this not a separate issue? This is whether the actions of the officers were causative of death.
I don't think that was really fully addressed.
So the analysis that you carried out was essentially a desktop exercise.
Yes, it was.
And insofar as there were consultations with the medical
Yes.
experts, or insofar as they were precognosed, you might have seen the notes from those consultations or precognitions, but you yourself didn't have the benefit of being present at those consultations or
That's
taking those
correct.
precognitions.
The only precognition I was in attendance was Martin Graves.
But so far as the medical experts are concerned, you were doing this on the papers, as it were,
Yes.
and without yourself having the benefit of exploring the issues that we've explored today
Yes.
with the writers of the authors of the reports.
No, and I understood that was being carried out by Mr. Brown and Miss Edwards.
Looking back, do you think it would have been helpful for you to have been involved in that process as the analyst, as the person who was looking at the evidence and looking at how the law applied to that evidence?
Possibly, but as I say, I was aware of and provided with the consultation notes.
I wonder if we can return briefly to page 24 of the analysis. We've looked at this already. The extent to which the role of restraint contributed to the death of Shekobayo is not known, but cannot be excluded completely. With the benefit of hindsight and, sorry, please can we stay at the top of the page, and reflecting perhaps on the issues that we have discussed this afternoon, do you maintain that that is a correct summary of the medical evidence in this case?
I think it's a very brief summary, and I think it's more nuanced than that. But and I say I'm not happy with the first line of that, in the sense of the restraint leading to the death, because I think the death followed restraint, and I think that's a more appropriate way to put it.
Well, let's imagine that we've made that correction so that it reads the restraint on the ground, or the death followed the restraint on the ground. Although, as has been set out in great detail in the narrative, the extent to which the role of restraint contributed to the death of Shekobayo is not known but cannot be excluded completely. I would agree with you that that's a brief summary. Is it an accurate summary?
I think I would say yes, with reference to the narrative in relation to all of the medical evidence.
So you would stand by the statement that the role of restraint is not known but cannot be excluded completely?
Yes.
And having reflected on the reports that we have looked at today, do you consider that the medical evidence was consistent with the view that the role of restraint was de minimis, or that it made a material contribution to death?
I don't think you can say with certainty it was de minimis, nor really can you say with certainty it had played a significant part in the death.
Can you bear with me just a moment, please?
It's 3 o'clock. Should we take a 15-minute break at this point?
Yes,
Very
thank
well.
you, sir.
Ms Thomason.
Thank you. Mrs. Carnan, I'm going to move on to the final chapter of questions that I have for you, and these concern race. Now, you have told us of your awareness of the requirements of Article 2 and Article 14, and that they underpinned everything that you did.
Yes.
And you have already acknowledged that there's no consideration of race in the analysis at all. And you gave a very brief explanation for that earlier in your evidence, that you were looking for criminality and race didn't really feature. And I want to look at that in some detail with you, and I think a good place to start would be to bring up the explanation that you give in your first inquiry statement at paragraph 45. So you were asked, to what extent was race a factor in your analysis of the actions of the police officers? In your view, was this sufficient to inform Crown Counsel of the impact, if any, that Mr. Bayo's race had on the actions of the police officers who engaged him? And you said, I was concerned with considering whether the actions of any of the officers, either individually or collectively, amounted to criminality. My focus was on the actions of the officers during the period of their engagement with the deceased and the evidence of how they conducted themselves thereafter. I did not identify criminality on the part of any of the officers involved. Had I identified criminality, it would then have been part of my analysis in respect of criminality to consider whether the conduct was racially aggravated under Section 50A1B of the Criminal Law Consolidation Scotland Act 1995, or whether race was a motivating factor that would amount to an aggravation of the conduct of the accused officers in terms of Section 96(2) of that Act. So you say here that your focus was on establishing whether there was evidence of criminality.
Yes.
You didn't identify criminality. If you had identified criminality, then you would have gone on to consider whether there was a basis for a racial aggravation under Section 50A or an aggravation under Section 96 of the 1995 Act.
Yes.
Now, to understand your approach, and really for the benefit of any members of the public who might be following your evidence, I think it might be helpful to look at the legislation. And it's set out quite conveniently in one of the chapters in the Practice Handbook. So I wonder if we could look at Chapter 44, which is COPFS 06411, and it's headed up Racially Aggravated Offences. Now, just to get our bearings, we can note in passing in the introductory section that there's a reference to Recommendation 12 of the Stephen Lawrence Inquiry Report by Sir William Macpherson, which states that a racist incident is any incident which is perceived to be racist by the victim or any other person. And that definition was formally adopted by the Scottish Executive. Would it be fair to say then that if the death of Mr. Bayo was perceived by his family to be racist, then his death would fall within the definition of a racist incident?
Yes, I accept that.
We could perhaps also note in passing in the second paragraph on this page that there's a reference to the prosecution code, which is underlined. It is stated in the prosecution code, the public interest is likely to require prosecution wherever sufficient criminal behaviour was motivated by any form of discrimination against the victim's ethnic or national origin or religious beliefs. So there is essentially a presumption that the public interest will be in favour of prosecution where there's evidence of a crime and evidence of a racial motivation or aggravation.
Yes.
Now, if we can go to the top of the second page, please. Beginning section 50A1. So this is a new section that was inserted by legislation in 1998 into the Criminal Law Consolidation Scotland Act 1995, and the section creates the statutory offences of racially aggravated harassment and racially aggravated behaviour. Section 50A1 provides that a person is guilty of an offence if he pursues a racially aggravated course of conduct which amounts to harassment and is intended to amount to harassment, or occurs in circumstances where it would appear to a reasonable person that it would amount to harassment, or acts in a manner which is racially aggravated and which causes or is intended to cause a person alarm or distress. And I think it was that second limb that you drew attention to in your statement 50A1 subparagraph B, which makes it an offence to act in a manner which is racially aggravated and causes or is intended to cause a person alarm or distress. As to what constitutes racial aggravation, we see a definition, if we scroll down the page a bit, please. A little further, please. There we are. Definition of racial aggravation. A course of conduct or an action is racially aggravated if immediately before, during, or immediately after the course of conduct or the action, the offender evinces towards the person affected malice and ill will based on their membership or presumed membership of a racial group, or the course of conduct or action is motivated wholly or partly by malice and ill will towards members of a racial group based on their membership of that group. If we continue to the next page, please, to look at the second of the two matters that you highlighted in your statement, where we see the heading definition of racial aggravation. If we could bring that to the top of the page, please. Section 96(2) defines racial aggravation for the purposes of Section 96 in the following terms. An offence is racially aggravated if, at the time of committing the offence or immediately before or after doing so, the offender evinces towards the victim, if any, malice and ill will based on the victim's membership or presumed membership of a racial group, or the offence is motivated wholly or partly by malice and ill will towards members of a racial group based on their membership of that group. And if we scroll down onto the next page, please, we see that the racial aggravation must be libelled in the indictment or specified in the complaint for this section to apply, and we also see that evidence from one source is sufficient to establish the aggravation for the purposes of that section, so corroboration is not required.
No, criminality is required, and
Yes.
then one source. That's correct.
Thank you. So, Section 50A, we can take this off the screen now, thank you, creates an offence of racially aggravated behaviour, and Section 96 provides that when an offence, and it could be any offence, has been committed, if racially aggravated, then you can libel that aggravation as part of the offence.
Yes.
Okay, so that's the distinction between
Yes.
the two sections. But in both cases, there's a requirement to consider whether there was evidence that immediately before, during, or immediately after the incident, whether it's a behaviour or an offence, the offender evinced malice and ill will based on the victim's membership or presumed membership of a racial group, or whether the behaviour or offence was motivated in whole or in part by malice or ill will towards members of a racial group. Would that be a fair summary
Yes.
of what those sections
Yes.
bring to the statute book?
Yes.
So we've looked at your explanation already in paragraph 45. Am I right to understand that essentially this was a two-stage process?
Yes.
You would look for evidence of criminality first,
Yes.
and if you found criminality, evidence of criminality, if and only if you found evidence of criminality, then you'd go looking for evidence of a racial aggravation or motivation for that criminality.
That's right.
Does that fairly set out the
Yes.
approach that you took? And if we can look in passing at paragraph 38 of your statement, this is your first statement. Thank you. Paragraph 38, and you essentially confirm your approach here. I was not involved in gathering evidence about race If my analysis of evidence had established that there was sufficient evidence to support criminal charges against any of the officers, the question of any racial motivation or intention would have been addressed at that stage. Since the analysis of evidence did not identify criminality by any officer, the question of racial aggravation did not arise, since no offence had been identified.
Yes.
So essentially there was no offence on which you could tag an aggravation or motivation. So you've been very clear as to the approach that you took, both in your oral evidence and in your written evidence. And what I'd like to do this afternoon is explore with you how that approach sits with your statement that the requirements of Article 2 and Article 14 underpinned everything that you did, including your work on the analysis. And that is because Article 14, read with Article 2, requires an authority to take all reasonable steps to unmask any racist motive and establish whether or not ethnic hatred or prejudice may have played a role in events, and to pursue that investigation with vigour. We spoke about those requirements of the ECHR this morning.
Yes.
Let's begin by looking at the way that you approach the officer's assessment of risk. Can we move to your second statement, please? And if we could look at paragraph 6. The question of officers' attitude, my focus was on potential criminality. The question of officers' attitude towards Mr. Bayo's race would only be relevant if there was evidence of criminality on the part of any officer. I found no evidence of criminality. In considering the question of criminality, an assessment was made about their perception of the threat posed by Mr. Bayo, both to the general public and to themselves. It appeared that the perception of threat was based on a number of factors, including the information provided to them in advance of their attendance at the scene by way of airwave messages about the male, their own observations, and what could and should have been obvious to them at each stage as the incident unfolded. It did not appear that their perception of risk was based on Mr. Bayo's race. You then go on to narrate the circumstances shared with the officers over the airwaves, and you go on to say, perhaps 6 lines from the bottom of the paragraph, that the man's race, whilst an undeniable fact, was of little significance to the officers in assessing potential risk in light of the description of his physique, the fact that he was chasing someone, and the fact he was carrying a large knife. And for completeness, I wonder if we can look in passing at the very bottom of your answer at question 7, where you say, I did not find evidence that the officer's perception of threat was influenced by Mr. Bayo's race, and therefore did not consider it in my analysis. So we'll return to this in just a moment, but before we do that, I'd like to look in passing at paragraph 16. And perhaps if we go on to the next page, we can stop there. Sorry, if we could scroll up a little bit so we get the bottom of the page above. Thank you, perfect. So the bottom line of the top page. For the officers, that assessment of risk was heightened by the possibility that they may be en route to a terrorist incident in the accounts provided by PCs Walker and Payton. That does not entitle them to act differently, but indicates their heightened state of awareness to the risk to their own safety and that of the public, and would inform their choice of approach and tools to deal with Mr. Bayo. So here you say that for the first officers, that is Walker and Payton, their assessment of risk was heightened by the possibility they might be en route to a terrorist incident. And I just wonder how that fits with the statements that you make earlier, that you didn't find any evidence that the officer's perception of threat or risk was influenced by Mr. Bayo's race.
I simply didn't make that link. They had been provided with intelligence in the months leading up to this incident. The intelligence was of a severe risk of a terrorist attack on the police. So they had a factual basis for asserting in their statements that they were at heightened, their awareness was heightened by that.
So you were aware that the officers or some of the officers had made references to the terrorist threat,
Yes.
and you fact-checked that
Yes.
and satisfied yourself. We see from the reading of the narrative and analysis that there had been an increase
Yes.
to the threat level to severe,
Yes.
and there had been, I think, 2 memoranda that had been circulated amongst the officers that are referenced in the recognition. So there is evidence that some of the officers were concerned they were attending a terrorist incident. First on the scene, as we know, were Constables Walker and Payton, and their statements were available to you. I won't bring them up on the screen, but I'll be corrected if anything I say is wrong. But Walker, in his statement, said, "It did cross my mind that he was doing this to get the police there, bearing in mind we're on a severe threat level for an attack on the police." And the severe threat level that he was referring to related to the threat of a terrorist attack on the police. Is that right?
Yes.
And Constable Payton, in his statement, said, "It also ran through my mind that this male could be part of a terrorist plot." And he describes that thought running through his mind before he got out of the van. And at a later stage, as events unfolded, and at the point that he'd been incapacitated by his own spray, he said, "I kept thinking about the Lee Rigby boy, the soldier who was killed." And Lee Rigby, of course, was a soldier in the British Army who was murdered by Islamist terrorists in 2013. Is that right? Is that
Yes.
your understanding? Now, as part of the process that you went through in your analysis and in ensuring Article 2 and 14 compliance, did you consider why the possibility of terrorism crossed their minds?
I asked the question, although I think it had already been answered, why they had considered terrorism, because they had a briefing. They had 2 briefings in the early months of 2015.
Okay. And did you consider whether they would have thought about terrorism if Mr. Bayo had been white?
No.
Did you consider whether they thought about terrorism every time they went to a knife call?
No.
And did you consider why Constable Payton thought about Lee Rigby in particular?
I simply noted his position.
So you didn't give thought to why he thought about Lee Rigby?
I didn't interpret it as being influenced by his race. No.
You didn't interpret it that
No.
way? No. Did you consider whether Constable Payton would have been thinking about Lee Rigby if Sheikh Bayo had been white?
I didn't ask that question. It wasn't the practice to recognise officers who are the subject of potential criminality, so I had to take his statement on face value.
I wasn't suggesting that you ought to have recognised the officers. I can see the difficulty there, but
Yeah.
sometimes as an analyst one can look at the facts and circumstances and perhaps draw inferences from them.
It's not an inference I drew.
Not an inference you drew, all right. And did you consider whether there was evidence from which the inference could be drawn that the colour of Mr. Bayo's skin was relevant to their concern that the incident was related to terrorism?
I did not make that assessment.
Now, Constable Good also thought about Lee Rigby, and she said, "I was also thinking at that point of the Lee Rigby incident in London, mainly due to the fact of the coloured male and the potential terrorist connotations." And again, her statement would have been available to you. So Constable Good made a link between the colour of Mr. Bayo's skin and the potential terrorist connotations. So you didn't need to draw an inference,
No.
so far as she was concerned, that she was thinking about terrorism because Mr. Bayo was black, because she said as much in her statement.
Yes.
And did her statement not perhaps cause you to wonder whether others who also thought about terrorism and or Lee Rigby had done so because of the colour of Mr. Bayo's skin?
I have to say no, it didn't.
And for completeness, Sergeant Maxwell, who arrived later on once the incident was underway, said, "A part of me considered this to be terrorism related based on recent intelligence and the threat level to serving police officers in the United Kingdom." So we have 4 of the attending officers have referenced terrorism and or Lee Rigby in their statements. Let's look at paragraph 8 of your statement, please. You say, "I've made no reference in my analysis of evidence to the use of racial tropes or negative stereotypes being used by any of the response officers in their statements. However, it is unlikely that I would have done so, since use of racial tropes is not criminal." And then if we can skip a paragraph and go down to PC Good and PC Payton, both made references to thinking about the attack on Lee Rigby, and I can see now how such reference could, on one view, be interpreted as a racial trope. On another view, their comments reflect their knowledge of intelligence briefings provided in recent months. As police officers who had been so briefed, they were alive to the possibility of this incident being terrorist-related. I would not necessarily view their comments as racist tropes. Evidence about negative attitudes of officers to Mr. Bayo's race would not be relevant to the analysis unless criminality was identified. Were you not concerned that Constable Good made a link between the colour of Mr. Bayo's skin and the potential terrorist connotations?
As I say, I was really focused on criminality, and PC Good had little to do with the events. She was right in the periphery of it. So as far as I was concerned, her involvement, the potential for her to be involved in criminality it simply wasn't there. She had a very minimal part to play. She wasn't really involved in the restraint until assisting with leg restraint at the very end. No.
Okay. And she may have had a relatively small part to play, and I cannot get into a discussion as to the offences you were looking at or anything of that sort, but you would at some point in your analysis presumably have had to address your mind to the question of art and part or concert.
Yes.
Okay. And to that extent at least, there was the potential for Constable Good to have been implicated had you found criminality
Yes.
in the course of the restraint.
Yes.
And you say that your focus was very much on criminality, but her mindset and the link that she made between the colour of Mr. Bayo's skin and terrorism could have been relevant to her state of mind?
Yes, and that would go to the question of mens rea.
Yes.
Yes.
And potentially could have been relevant to concert.
Had criminality been identified?
Had
Yes.
criminality been identified, but whether criminality was identified or not, you had a responsibility through the recognition process to ensure that your analysis was Article 2 and Article 14 compliant?
I think I had a responsibility, or that the responsibility was on the investigation as such. My
Mhm.
responsibility, as I understood it, was to report on criminality.
Okay. And you say in your statement that Articles 2 and 14, you were aware of what they
Yeah.
required, and
Yes.
they underpinned everything that you did.
Yes. But also the application of the law.
Mm-hmm. By that, do you mean the domestic law?
Yes.
Because we've already examined that there doesn't appear to be any analysis of the requirements of Article 2 in terms of lawful use of force within the analysis section of the recognition. So your focus was on domestic law
Yes.
rather than on the ECHR.
Yes.
Would you accept that Article 14 is part of our domestic law?
Yes.
Article 2?
Yes. I suppose it's the extent to which they relate to each other.
Mm-hmm. And the extent to which they relate to each other, you've already accepted is not an issue that you exposed to the
No.
light in your analysis. And insofar as you took the view that there might have been a tension between domestic law and that, we can't get into that conversation because I can't ask you about domestic law today, but to the extent that you might have thought that there was a tension between domestic law and the ECHR, that is not set out and
No.
exposed in your analysis.
It's not.
Okay. Returning to Constable Good and the link that she made between the colour of Mr. Bayo's skin and the potential terrorist connotations, did you consider whether the link she made was reasonable or whether it might have been indicative of racial stereotyping?
I considered it was not unreasonable given the briefings. Was it indicative of racial stereotyping? Possibly.
You're saying that. Are you saying that now with the benefit of time to reflect, or did you think that at the time?
I don't think I thought it at the time.
Okay. You didn't think it at the time, or you didn't consider it at the time,
I didn't think it at the time.
even though she said in terms that she had made a link between the colour of his skin and terrorism.
No.
So at the time you didn't think of that as racial stereotyping. With the benefit of hindsight and reflection, your evidence today is that it could be indicative of racial stereotyping. And if it had occurred to you at the time, or if you'd thought that way about it at the time, is it something that you might have included in the analysis?
It's possible, yes.
Insofar as it perhaps could be said to shine a light on her state of mind, and that would be potentially relevant to mens rea if you were in a situation where you'd found criminality and you were looking at art and part or concert.
Yes, in terms of criminality, yes.
And that's leaving to one side whether there might have been a desirability to explore these issues from the point of view of ensuring that your work was Article 2 and 14 compliant.
Yes.
Let's look at paragraph 15. If we can look at this bit at the bottom here that begins the question of reasonableness. The question of reasonableness of the police decision-making and action was considered at each stage against their state of knowledge, their perception of risk and their training. Had I considered that their perception that the call to the locus could have been terrorist-related was unreasonable, I think I would have said so in the analysis of evidence. I considered that, given the recent memos, their speculation en route to the scene of the knife-carrying male being a terrorist was not out with the realms of possibility and therefore not unreasonable. So you were not concerned, you've told us already, that some of the officers believed this could be a terrorist incident, and you didn't consider that concern was unreasonable.
That's correct.
Simply because something isn't out with the realms of possibility, it doesn't follow that it is reasonable. Would you agree?
They may not be the same thing.
They may not be the same thing. And if the only reason that they thought that this was a terrorist incident was because of the colour of Mr. Bayo's skin, would that be reasonable?
I didn't read that into their statements.
That's why I used the word if. Hypothetically, I mean, we can read that into Constable Good's statement, but so far as Walker, Payton and Maxwell are concerned, we perhaps can't. But if an officer thought that this was a terrorist incident because, and only because of the colour of Mr. Byers' skin, would that be reasonable?
Possibly.
Can you expand on that?
Because of their experience about what terrorist incidents had taken place previously, such as Lee Rigby.
Do you mean because terrorist incidents that had been reported in the news had involved men who were...
In the recent past, I mean, if you go back 25 years, you could be talking about people with an Irish accent, or, you know, so I think it would depend.
Okay. But insofar as you might consider that to be reasonable, should we understand that what you're saying is that that would be because there had been recently reported terrorist incidents where the terrorists who had carried out certain atrocities were black or perhaps from an ethnic minority background?
It would be a factor.
It would be a factor.
In their perception.
And you say that could be a reasonable perception?
It could be.
Let's look at paragraph 17, please. If we can look at the sort of second half of that big paragraph, it's about 10 lines from the bottom. I did not have a concern. I'll let you find the place there. Mrs. Carnan, thank you. I see that the cursor was being held over it. Are you with me?
Yes.
I did not have a concern that some officers were speculating that they could be dealing with a potential terrorist attack following the report of a black male with a knife. They had received intelligence briefings in the previous months and were on high alert for potential terrorist attacks. Such an attack was not out with the realms of possibility. The fact that they made an association between the report of a black male with a knife and recent memos warning of a threat of a terrorist attack was not of itself of concern in the context of assessing criminality, which was the focus of the report. Now, evidence of a racist motive for behaviour will not always be overt. Would you agree with that?
Yes.
Okay. And it may be a question of drawing an inference from facts and circumstances.
Yes.
Now, I wonder whether when you embarked on the process of your analysis, you turned to any sources of guidance or information to guide you on how you might approach the question of race. Is that something you did?
No, because I didn't get to that point.
I see. So we have heard some evidence in the inquiry that the IPCC issued a set of guidelines on investigating allegations of discrimination, including race discrimination. That was in 2015. Were they on your radar back in 2017?
No.
Are they on your radar now?
No.
All right. As part of your process, and I appreciate that your focus was on criminality, but you have told us that Article 2 and Article 14 underpinned all that you did you consider whether the language used by the officers in their statements might indicate a racist frame of mind?
It did not, that did not seem to be the case. But as I said, I wasn't looking for racial motivation at that stage because I had not crossed the threshold of criminality.
Okay,
So it wasn't a test, it wasn't an exercise that I undertook.
I appreciate that you didn't undertake that exercise, but there are a number of specific points that I would be interested to know whether they were within your thinking and your mindset as you approached your analysis. We've spoken already about terrorism and Lee Rigby. I'm sure that you will be aware of racist stereotypes in society, that black men are more violent, unpredictable, aggressive. You'll have come across these stereotypes, I would imagine.
I have.
And did you examine the officers' statements for language of that sort?
No.
Did you consider patterns of behaviour, whether, for example, they had used their sprays or drawn their batons at previous knife incidents?
No, I was simply concerned with this incident.
Okay. Did you consider whether they treated all knife calls as potentially terrorist related?
No, that wasn't a question that was asked.
Did you consider looking for comparator evidence, for example, looking at Walker, Payton and Tomlinson's history of use of spray, or Tomlinson's history of use of force involving a baton, with a view to establishing whether those officers had ever used sprays or batons before?
No.
Or whether they had used sprays or batons when detaining a white suspect?
No.
Did you consider whether the speed with which the officers elected to use force against Mr. Bayo was because he was black?
That wasn't my understanding. I think I've explained in one of the answers my understanding of their perception was based on a whole lot more than the colour of his skin.
Okay. Did you consider whether Constable Walker and Constable Payton's decision to opt for a hard stop may have been influenced by Mr. Bayo's race?
Again, we didn't cross the threshold into criminality, so that wasn't a consideration per se.
So you've explained that you took a two-stage process. You looked for evidence of criminality. You didn't find it, so you didn't get past first base,
Yes.
essentially. And it would only have been if you'd found evidence of criminality that you would have scrutinised the evidence for evidence that might allow you to draw an inference of racial aggravation
Yes.
or motivation. With the benefit of hindsight, and in light of your statement that everything that you do is underpinned by Article 2 and Article 14, do you think that the approach that you took to analysis of the evidence, as far as race was concerned, was adequate?
I think it was adequate in terms of assessing criminality.
With hindsight, do you consider that your approach pursued with vigour all reasonable steps to unmask any racist motive and establish whether or not prejudice may have played a role in events?
In the context of assessing criminality, yes, because that's as far as I got. So therefore, I understand your question, but I revert to my focus was on criminality.
So if your focus wasn't on pursuing with vigour all reasonable steps to unmask any racist motive, then who was focused on that task?
I don't know if that was a focus for this stage of the report to Crown Counsel.
You've explained that your focus was on criminality.
Yes.
You accept that the Crown investigation required to be Article 2 and Article 14 compliant.
Yes.
So if you weren't investigating this particular aspect as required by Articles 2 and 14, I wonder who, if anyone, was, and your answer to that, I think, is that that was for another day.
Well, if there wasn't criminality, then everything else needed to be looked at.
So was it anticipated then that if Crown Counsel instructed there should not be criminal proceedings, as in
Yes.
fact happened, that there would be a further precognition process or some sort of addendum to the precognition that would explore all of these issues?
I could tell you that in normal practice, there would be a precognition report to Crown Counsel considering a fatal accident inquiry and the issues that would be addressed in that.
Okay. Okay. And did that happen in this case?
No, it didn't, because as I understand it, a decision was made that a public inquiry should take place in that, preceded any further report to Crown Council.
So at the point that a public inquiry was announced, did the Crown effectively down tools on its own investigation?
I can only speak for my involvement.
Is it possible then that the Crown investigation is essentially an incomplete one?
As I say, I can only speak to my involvement in the Crown investigation. I can't speak to what else was going on.
But certainly as the analyst, no one came back to you and said, Crown Council have instructed there shouldn't be proceedings here, so now we need to look at an FAI.
No, that wasn't the...
That didn't happen?
That didn't happen, no. And as I say, my role was very much on looking at criminality.
Okay. With the benefit of hindsight, is there any aspect of your analysis that you might approach differently now, other than those aspects that we've discussed already and you've said you might approach differently?
I don't think so.
Can you bear with me a second? Just one final thing, Mrs. Carnan, and I
Yes.
appreciate that your role, your remit was limited.
Yes.
And you might not be able to assist us with this, but I think what you were saying is that the Crown, perhaps to date, haven't fully explored Article 2 and Article 14 because they only got as far as preparing the recognition in connection with possible criminal proceedings, and then a decision was taken that there should be an FAI, sorry,
No,
public inquiry. Sorry.
Yes.
So if that is the case, and we'll hear from others within Crown Office whose involvement went beyond yours as to what might have been going on,
Yes.
beyond the point that your recognition report was submitted to Crown Council. But
Yes.
if that's what has happened here, and there certainly isn't before the inquiry a supplementary recognition addressing an FAI or
No.
anything of that sort.
No.
But if that work is essentially unfinished, and if the Crown have, in fact, never fully explored Articles 2 and 14 of the ECHR, you will be aware that Article 2 requires an investigation to be reasonably prompt and for delays to be avoided. Would that mean that any responsibility that fell to the Crown to carry out an investigation and a prompt one at that has not yet been satisfied?
I don't think I can answer that.
All right, that's maybe for another day. Okay, I have no further questions,
Thank
thank you.
Are there any Rule 9 applications? Right, Mr. Adam. Mrs. Carnan, would you mind withdrawing to the witness room, please, for a moment or two? Yes. Yes, Mr. Henry.
Yes, thank you, sir. There is one matter which I would wish to address with this witness. It relates to an entry in a notebook used by her, which is COPFS 05222. This document isn't paginated, but it is at page 28 of the PDF. Thank you. Sir, you'll see the first line of this page which says points race card. It is this reference to the term race card that I wish to explore with Mrs. Carnan, which I'd like to ask her about her understanding of the term race card, including whether she's aware of any pejorative or negative connotations in relation to the phrase, what she understands it to mean if someone is accused of playing the race card, and her reasons for using the phrase in her notebook.
That's the point.
That's everything, sir.
Yes, very well. I shall allow you to ask that. If we can have the witness back, please. There might be a little rearrangement of seating here. Mrs. Carnan, Mr. Henry is junior counsel for the Coalition for Racial Equality and Rights. Has some questions for you.
Thank you.
Thank you. Mrs. Carnan, I have a question about an entry in a notebook which I understand was made by you. It's COPFS 05222 and it's at page 28. Firstly, Mrs. Carnan, do you recognise that writing?
Yes.
Is that your writing?
Yes.
Mrs. Carnan, I'm interested in the first line of that page where it says points race card.
Yes.
And it's the phrase race card that I'm interested in. What do you understand by the term race card?
A suggestion that race played a part in an incident.
Are you aware of any pejorative or negative connotations to the phrase race card?
No.
What do you understand it to mean if someone is accused of playing the race card?
That they are raising the question of race.
No other meanings behind that phrase?
No.
Thank you, Mrs. Carnan. I've no further questions for you.
Mrs. Carnan, thank you very much for coming to give evidence to the inquiry. I'm grateful for your time. The inquiry is about to rise for the day and you'll be free to go.
Thank you.
Adjourned till tomorrow.